right. Everybody hear me okay? See some nods in the back of the room. Good. I won't need the clicker. No PowerPoint to distract from what I'm sure will be a scintillating presentation on subjects that may appear to be trivial at first compared to all the great stuff that we've been hearing about in the scientific and engineering part of applying remote sensing. But as you might imagine, from my point of view, they seem like some of the most important. And I hope I can convince you the same this morning. I've been a water rights attorney for something like 35 years and have litigated in the administrative arena in New Mexico. I live in Santa Fe, and also in the United States Supreme Court. We have occasion to bring water cases directly to the Supreme Court of the United States when there's a dispute between states. As you may recall, some of you history buffs, Ben Franklin was the first to suggest that we needed some way to resolve disputes between colonies. And then they became states, and we had a section of the Articles of Confederation, another document I'm sure you all are familiar with, which took about 1/7 of its total column inches to set out the procedure for resolving disputes between states. Now it's very simple under the Constitution. It's one line in the Constitution that says that the Supreme Court of the United States shall have original jurisdiction in cases involving states. So we have had some ET battles in the forum of the United States Supreme Court as a result. Some years ago, we were litigating on the Arkansas River, or as my client, the state of Kansas, calls it, the Arkansas River, over a compact between Kansas and Colorado. And this had followed on many years of disputes over the Arkansas River waters, starting back in 1900 when the legislature of Kansas first asked its attorney general to sue Colorado in the original jurisdiction of the Supreme Court, as we call it. They did. Colorado objected at that point that there was no jurisdiction in the Supreme Court to do that. And it was a watershed moment, so to speak, when the Supreme Court came back and said, no, we will decide the allocation of interstate waters in interstate rivers, if the states can't agree. This went on for the better part of the first half of the 20th century. A compact was entered into. There's also this option. Once you know a court can give you some relief, then there's some motivation for a state, an upstream state, to say, okay, I'll talk about sharing this. But if there's no cause of action, like the one that was recognized in 1902 for a lower state on a river to bring a case to the Supreme Court and get an allocation between the states directly from the court, there's no motivation to agree to it ahead of time. But after that was established, then states began to agree to compacts. You've all, I'm sure, at least heard of some of these compacts. Colorado River one was the first one that was negotiated. We've learned some things from that experience when there was a hard and fast delivery requirement to the lower basin. The compacts since then have been drafted. They're all unique. They have unique characteristics, each one of them, but they, in general, are now adapted to the water supply. If the water supply goes down, everybody's share goes down. It's a typical situation. And so that's where we happen to have the possibility of having some of these disputes resolved directly in the Supreme Court. As we've heard earlier today and yesterday, there are good opportunities, or many opportunities, I should say, for using determinations of ET in every phase of natural resources management. And I would add in private transactions, if you're going to sell your water rights, the real important aspect is the consumptive use. And that is where ET comes in. And parties typically will set when they're buying and selling water rights. They'll say, I'll pay you so much per acre foot consumptive. And usually it's what the ruling state agency will say is recognizable consumptive use, actual consumptive use. We have to distinguish in this area between potential and actual consumptive use. We had an occasion in the Arkansas River litigation where we needed potential consumptive use, potential ET. There was a model there that is called the hydrologic institutional model, and we spent most of the 13 years that we were in trial. Now, it wasn't every day, but over that 13-year period, we were in trial for probably 270 some days. And I would say of those days, probably 75% of that time was over the model. And ultimately, the purpose of that model was to determine the consumptive use, the actual consumptive use of water in Colorado. And there was a lot of, the issue there was the groundwater pumping that had been initiated to supplement surface water use in Colorado. And when you added them both together, it turned out they were using more than the compact allowed. The criterion in that compact was that after the date of the compact, which was about 1948, there would be no new depletions to depletions, is what I should emphasize, to usable state line flow. So it keyed right into depletions. You can divert, and that's not the whole answer, of course. You've got to figure out what the return flows are, and in that mix between diversion and return flows is the consumption that you're really looking for. So one of the issues that we had in that case, just to give you a demonstration of the experience we've had in litigating ET issues in the United States Supreme Court, we had a model that simulated all of the fields, the ditch service areas in the section of the river that we were looking at, which was, as I recall, it was 150 miles, and it had 29 active canals coming off of it. The biggest one, I think, had a capacity of like 1,200 CFS. And this model had an upper limit on ET that was originally determined in the early parts of the litigation, which occurred in 1990, according to the modified Blaney-Criddle method. And as we pointed out to the special master, by the way, they appoint special masters when they have a Supreme Court case like this in its so-called original jurisdiction. It's called original because it originates there. It doesn't get appealed. Most of the cases we hear about in the news are ones that have been appealed from lower courts. These cases are not appealed from lower courts. They originate in the Supreme Court. No other court has jurisdiction, and there's been a few instances where a lower court has thought that it could make some rulings that implicated interstate rights, and the Supreme Court has slapped them down and said the only way you can do it is come directly to us. Nevertheless, by the way, they exercise discretion. They won't take necessarily every case. So if you're in that exclusive area where they exercise their exclusive jurisdiction, you have to convince them that it's a serious and dignified claim and that there's no alternative forum. One case I like to cite to illustrate the seriousness and dignity of the case, I'm not sure you all would agree with the court's ruling on this, but there was a case, an interstate case, over which the court had exclusive jurisdiction by one state against another for breach of a contract to play a college football game. And there was a contract, and it was admitted by the court. That was the only forum. It was an interstate dispute, but they said, no, we're not going to take our time to resolve that. Now, I'm sure there are people who would disagree with that, but that was it was not without dissent. Justice Stevens, for instance, dissented from that decision. And then the other criterion they apply is whether there's an alternative forum. If a case can be first treated through, say, a federal agency, a good candidate might be the Corps of Engineers. If a river is being essentially run by operations that are controlled by the Corps of Engineers. They want you to go and sue the Corps of Engineers and see if you can resolve your issues with the Corps. Eventually, those kinds of things can come to the United States Supreme Court through the appeal process. But in these truly interstate cases, and the ones where you're enforcing the compacts that have, and a compact is an agreement, it's just like a treaty, an international treaty. The only difference is this one will be enforced. The Supreme Court has pointed out that the approval of Congress and the President means it's a federal statute, and that's what they know how to do, is enforce a federal statute. And we have seen this in the Ark River case. They did enforce it, and as I was starting to say, one of the issues was, what is the consumptive use of water by crops? In other words, you have an extra well, a post-compact well, it's pumping water, it's putting that on a field. How much of that water is being burned up, evapotranspired, and how much is going back into the river and coming to the downstream state? And we had the modified Blaney-Criddle answer as the top for the potential there, and we were able to convince the court. It was I would call it a knockdown, drag-out fight that went on for weeks in front of the special master who was appointed by the court to hear the case, as to whether this should be adopted and if there should be certain deductions from the straight potential ET answer that we were recommending. Ultimately, he adopted the Penman. It was a Penman-Monteith methodology that we were recommending, what is now known as the ASCE Standardized Penman-Monteith. And that is now in place in the Supreme Court decree as the upper limit. Now, it's what we are really looking for, and it goes to the subject of this conference, is actual ET. And that model has that as the max, but if water supply or other reasons that are recognized by the model, you don't reach that maximum ET, then you don't get to the potential. Once in a while, you have everything works out and it bumps up and it'll hit that potential number. But really, that's because the actual is equal to the potential at certain times. But you don't want to use the potential all the time, because that's just not factual, and that's what the remote sensing methodologies go to. So I feel very optimistic about the ability of the courts to accept this methodology ultimately if it's done right. We've heard examples of how it is being treated in these cases. It's getting peer reviewed. We saw that was one of the criteria for admissibility. But I will say, sometimes peer review is overestimated. In my humble opinion, the toughest peer review you'll ever get is when you're in court and there's somebody being paid big bucks to show why you're wrong. And that's what we had in that fight over the Penman-Monteith. We had very able opposition, and as I say, it went on for weeks. And it was quite a challenge trying to explain stomatal resistance to the special master and get him to really get enthusiastic about it. But we, I think, learned from that there are these threshold admissibility considerations that were treated in one of the earlier talks, but that's only the first step. That gets you in the door. What you've really got to do is convince that trier of fact that you're right, that he can rely on you, that money can change hands over you, over that stuff. We hear a lot of times, oh, well, this is all well and fine, but it's academic, experimental, it's great for planning purposes even, but if you're actually asking somebody to fork over hard cash, it better be pretty reliable. And it's a pretty effective argument, and you've got to be ready to prove to the satisfaction of the court, not just the admissibility of this evidence, but that they really should rely on it in opposition to all the other possibilities of what they could do. So you need to be sure that when you do this kind of stuff, at least based on my experience, that you have a good explanation so that you can show the trier of fact why it makes sense and answer all the questions that can be raised by the trier of fact and by your opposition. And they will look for everything. And that's their job. And that's why they get paid the big bucks. And you've got to, first of all, try to anticipate everything that may come up in terms of reliability. These factors, as it's pointed out in the descriptions of metric, the final ET is only as accurate as those constituent parts that go into it. And there's a lot of subjects that at least can be raised. And as you're probably aware, in court, there's no limit to what people can think of to raise. Stuff that you would never have thought they could do. And if they're good at it, they could make it sound plausible. And you've got to, in addition to trying to anticipate everything you can, you've got to be ready when those opposing expert reports come in and talk about how lousy your method is and how lousy your data is and how lousy your QA/QC is in ways that you may not have anticipated. You need to be ready to hop onto that and figure out how you can convince the court that criticism is not right. I'll conclude by citing an instance where in one of our Supreme Court arguments in front of the 9 justices, and you have to, the justices, they don't have a lot of confidence that they know about this stuff. I think they're a little bit uneasy when you get into some of these water cases and the technical aspects of them. But there again, you need to try to explain things as clearly and succinctly. You've only got, when you're arguing one of these cases, you may have been in trial for 272 days, but you only get half an hour to defend your side of the case. Remember, I took some of those few precious minutes one time to explain to them how many acre-feet the Supreme Court courtroom will hold, to give them a sense of what an acre-foot is. And I had checked with the architect of the Supreme Court and my experts, and we had figured out between the pillars, that courtroom will hold 3 1/3 acre-feet. And Justice Stevens leans over the bench. He said, "Mr. Draper," he said, is that 1 foot deep or 3 feet deep or all the way to the ceiling?" He said, "It's all the way to the ceiling, Your Honor." Somebody asked me later, they said, "Did you hear what he said after that?" I said, "No." He said it usually doesn't get that deep in here. But I checked the record. They didn't put that down if it occurred. But in one of the more recent cases that we've argued up there, I think it just is particularly appropriate to this subject matter that we're discussing. Early on in the argument, I wasn't doing the argument on this one, but I was sitting right there about 3 feet from Justice Breyer, and he leans over and he says, "You're talking about consumptive use," and we were. He said, "I'm going to ask you a question, and then I'm going to answer it." And he said, "My question is, did they really know back at the time of the compact what the consumptive use was?" And my answer is no. And therefore, how could they have meant to regulate it? And I think our collective job is to tell him, and his fellow justices, to show them that we can do that. We do it all the time. We've got a way of getting closer to the real answer. We have all these potentials and so on, but in the end, we want actual. And here is a way that we can get to actual. And I think they're smart enough. They don't have the confidence, but they're very smart. And given a little time, a good explanation, good documentation. You've got to think about all this. You've got to have the documentation. There was a lot of good example of good documentation that I saw this morning that you can pull out if necessary. I think the prospect for acceptance of metric and remote sensing to determine actual ET is a bright. There's a bright future there. Thank you very much. You want me to?
We have time for a few questions if anybody wants to jump in. Okay, if no one's going to jump in, I'm going to use them. Oh, okay, I'll let Dave jump in.
Yes.
You know, Forrest had a question earlier about the most difficult question that Bill Kramer had to answer. And I'll ask the same question of you. And what was it, when it was Kansas and Colorado in that long testimony? What was the most difficult hurdle that you had to address to be successful?
Well, I don't know. You know, if I think about all the days of trial, it's hard to pick out a single one. I can tell you one thing that I don't recall the substance of the question, but when I was doing an argument one time with the 9 justices, I had one of the most difficult things I had come up. A justice asked me a question, and I thought to myself in that split second, that is the dumbest question I have ever heard. Now, how do I keep from showing that? And what do I say? And luckily, Chief Justice Rehnquist said, oh, let me ask you this, and then we'll come back. And we never came back to that question, and he was the most senior. So he saved me. I was able to answer the other question and saved me from some difficult times. But as far as the substantive questions, you know, it's just, I guess it never ceases to amaze me the objections that people can bring forward to your evidence. You know, it might even be, we're dealing with, we've dealt with a case recently. We went to trial on one of these cases in August on the Republican River between Kansas, Nebraska, and Colorado. And things that have been accepted in the previous Arkansas River litigation, that didn't make any difference to the other side. We said, hey, the court's already accepted this stuff. They're going, oh, they shouldn't have done that. It was dumb. This is, you know, they had no shame. They had, you know, and you know, you have to address it. And they're saying, oh, well, they got by easy on that one. Well, we're not going to let them by on it this time. And so it's a continual struggle to make sure you're ready, and even ready for things that you think, well, the court's already accepted that. I'm not going to have to worry about that. You know, it's in the particular instance I'm thinking of, it was one where the special master had accepted evidence of ours, and the other side had decided not to challenge that in front of the justices. So it was the decision of the court, but the court hadn't actually specifically addressed that question and said, yes, we accept that particular factor, for instance. And so you have to be ready to come back and maybe refight some of these wars that you thought you had already gotten by. So anyway, that's a general answer to that.
I've got one quick question.
Sure.
I started my academic career in Kansas, so it is the Arkansas River, just to let you know.
Just for the record.
But in regards to that decree, I do have an interesting question. I mean, with metric, and you've seen what's coming out of this conference, is very, very accurate, you know, estimates of consumptive use. And what I'm kind of curious about in regards to the decree and the depletion question is that many areas of the country have seen kind of increases in nighttime temperature, low expansion of the growing season, which even if you're not changing crops or you know, doing anything different, you're going to have increases in ET, consumptive ET over a season. And you know, you have a tool now that would actually be measuring this. Just in your opinion, how would the court view that in regards to the compact? With the simple change in growing conditions causing extra depletions require reduction in crop acreage in the upstream state? I mean, just kind of hypothesizing there, what would be your interpretation of that if a tool like metric was sort of demonstrating that it was creeping up over the years?
Well, I think that is a question that could come up. I think it depends on the particular compact or decree that you are involved with. Some of them are very explicit about consumptive use. And typically, things that man doesn't have control over that are natural, like phreatophytes and so on, the upstream state is not usually held to account for that. But if you, let's say, have your same acreage, but because of the factors that you mentioned, your ET has gone up, and we know there's a linear relationship between ET and yield, right? So your yield is going up. The farmer's taking home a few extra bucks. He's got a few extra bushels there, not because he's increased anything intentionally, but I think in one like the Arkansas River Compact, which specifically mentions depletions, I think it would be held to the depletions. I think it would.
Yes, it is. It'd be interesting.
You might have a different answer under another compact. You have to look at that. Ultimately, I think we get down to depletion even in compacts. But sometimes it's very clear like that. Other times, I think you've got to infer that. I think it's a proper inference, but you have to recognize that the court does consider these compacts and its own decrees. In some cases, the decrees are very simple. There's one on the Laramie River that the court adopted originally in 1922 that limits the amount of diversion in the upstream state. You can't take more than so many thousand acre feet through your diversion works, and that's it. And presumably, you could maybe change the consumption on that. So there's getting to, we've always been, for many years, we've been kind of circling this question of actual ET. You can limit it to some extent by the amount you divert, but not totally. And you can limit it by the type of use. Oh, this is agriculture, it's not municipal or whatever. But we know that different methodologies of applying that to beneficial use, even within those categories, can change the consumption. And under some divisions through decrees or compacts, that wouldn't be possible. And whether the ones where you have to infer such a limit would have the same requirement is something that's probably going to have to be litigated.
I think we have time for one quick.
Yes.
Yeah, one word that is missing in your talk and missing in maybe many of the compacts is what about water quality. And my question to you is there any movement in all these court cases that people start talking about, including water quality aspects in these compacts? Because if we don't do that, I think we will face a really big problem not too long down the road.
Yes. The question is whether these compacts affect water quality, limit or control water quality, or whether they should, and whether we're seeing anything in that direction. I think we would find, under the right circumstances and given the right set of facts, that there is implicit in these compacts a water quality aspect. These compacts are often in the West, where we have the prior appropriation system. Some of those compacts incorporate it to a greater degree than others. But part of that doctrine is, in addition to not impairing other water rights if you're going to make a change in terms of quantity, impairment by quantity, it's also if you impair the quality to the point where it cannot be used for the use for which that other water right is appropriated. In other words, if you're going to put in a new well and you're going to pull some salt water into your neighbor's well, He can still get his water, but now it's too salty for him to use. I think there's a cause of action there under the prior appropriation doctrine, and I think we would find it under these compacts. But it's implicit and would not go down easily, not without a court case. And the practical way of dealing with those issues these days is to do it through the agencies that control water quality. And that's the way the court would like to see it done. And there have been some issues up in the Chicago area and New York and New Jersey and so on. There have been instances where the court's original jurisdiction has been invoked for water quality purposes, and the court has basically said, go work with the agencies, go work with the EPA, and you can appeal from their decision if they won't give you the kind of help that you need. And the EPA has adopted certain standards that apply just upstream of state boundaries in rivers, that kind of thing. And if the downstream state thinks that that's not a tough enough standard to protect their uses, they can be part of those proceedings, and eventually, if necessary, can be appealed to the Supreme Court.